people, we must start with the person who authorized the payment. In fact, in terms of interest and advances, I think the PFM is very, very clear on the responsibility of accounting officers. So, Pesa iko wapi, Governor? This 1.6 million can build an ECD classroom. Kuna ECD classroom hapa ya 1.7 million. Yeah. How do we get back this money?
Chair, these two persons were in the first government, and they were CEC members. And as we have heard from the Director of Human Resource, the documentation that had all these details, somehow we were informed that the office or the place where the documents were caught fire and all the documents were burnt. So there is no evidence for us to be able, and I think that's why.
But Governor, if you and the auditor agree that this advance was made, then there must be a record that the advance was paid. Because if there's no record, why is it in here? Why are you even responding to it? If there's no record, why is your county attorney seized of it?
I have him. He's here.
The Chair, let's be a bit prudent with public money. Why this money was advanced in 2016, okay? 2015. Why does it take 10 years before the county attorney issues a demand letter for the recovery of this money? Yet he knows the statute of limitation may not allow him to recover that debt now. Is that negligence on his part? Huh? Because I'm looking at Annexure 3C, Chairman. The demand for the repayment of this money was made on 5th of June 2025. Why that long inordinate delay?
Chair, I really wanted evidence, as alluded by the HR officer, that the officers indicated that they want evidence that that money was advanced to them. How would you know money is advanced to you? It's because either there is a wire from the county coffers to your account, or you have signed. So for the documentation, maybe the documents might not be there, but if there was a wire from the county CRF account to that officer, and that officer expended that money, then why should you want evidence whether that money was advanced to them or not? It should be very clear, because that money went to that person's account. Chair.
Governor?
Chair, I think my position is that is the Director of Human Resource that keeps all these records and should be able to avail them. But this is the explanation he gave, that he couldn't get the documentation because of that fire incidents which led to the burning of the documents.
But then what would be the basis of your demand letters? Letter of demand before action and recovery? I don't know whether it's the one you're referring to that were done sometime in...
Yes, and we want to understand from the county attorney whether he understands the Limitation of Actions Act in terms of debt recovery.
Chair, let me confirm that I understand the Limitations of Actions Act and the limitations.
What is the period? So that we test whether you are supposed to occupy that office?
Yeah, if it's on contract, then we are talking of 6 years. If it's related to land, it's 12 years. If it's related to tort, it's 3 years.
So what was this one? What was it relating to?
Chair, this is public money, and we received instructions from the Treasury. If you see If you look at Annexure 3B,
No, was it within or it was already time barred? You're a lawyer.
Chair, we had worked. This is public funds.
You are sure you can file a suit?
Because you know the debt had not been written off. It was still a liability that was pending.
Are you a member of Law Society?
I'm a member and I'm a very senior member. I was admitted in 1987.
Fine, so educators,
No.
because
The limitation.
Tell us on the limitation.
Limitation
1980.
of Actions Act.
Governor, you may be very unfortunate if that is your county attorney who cannot understand
Limitation of actions.
basics on the time you need to file suit before you are time barred by the court.
Chair, that is very unfair, with the due respect, because
County-
I have not filed any suit.
County attorney, relax. Relax. Yeah? There's no need to raise your temperature. There are documents here which you have authored on the 5th of June. And perhaps it looks like you're doing the right thing, because I would have told the governor to advise you to do exactly what you have done. But senior counsel is raising a flag that due to the statute of limitation, this might be a futile exercise. That is what we need to deal with. I don't care when someone was admitted or what. Is this a useful exercise or it is a futile exercise? Let's establish that as a matter of fact, not as a matter of opinion. It looks like the right thing to do.
Chair,
But is it going to yield the results that we need?
Chair,
Before
we
it comes on board,
just issued the
Order through the chair. Wait, before it comes on board. I have read the letter that you wrote from County Attorney Honorable Sande Mukuna for the information. In the last paragraph, which was written 50 June 2025, so mark the date, say we intend to file the suit in accordance with the instructions within 21 days from the date of this letter, unless the amount is faithfully by a banker's check in favor of the county government of Vihiga. I thought I had the county attorney say he never had intention of filing the suit. So is this his own letter or we are reading other letters? It was written by him. And there's the Limitations of Actions Act. So where is he standing?
So, because Governor, you might be pursuing this through the wrong rabbit hole. You might think that you can go to court and enforce recovery when the PFM Act and regulations would suggest a surcharge on the officers responsible. You know, there are very clear provisions, the PFM Act and regulations, such that if you are not able to recover this money through other means, you go back to the officer who occasioned the loss of the public funds. So the question, is this route that you are taking going to bear fruit, Governor?
Based on what I've learned and gathered from this meeting, we may not be able to gain anything with this route. That's what I've heard, and I'm not a lawyer, but I've heard two lawyers talk, and I want to say that we have to look for another route, because this may be a futile route based on what I've heard.
Maybe to give the county attorney just a little bit of benefit, when he was admitted, some of us were still in school. What is your advice to the governor on this particular matter?
Chair, when you look at our response, we have already made a conclusion that we are not going to pursue further. These are some of the days that we may seek the proper procedure of writing them off. But Chair, even when somebody owes you, and you know very well that maybe you are limited by statute in terms of time, writing a demand notice may yield fruit. If the person acknowledges, yes, I owe the money, you know very well time will stop running, and you'll have the right to recover the money. So when I acted in accordance with the instructions, I expected a response from the person But the people responded and said that, okay, we want evidence that we owe the money. So this is the evidence I went back to the relevant department to find out, and that is when I was told the relevant documents were burned in a building, and they have not been recovered. So the next move...
they've put you on a wild goose chase.
I think so.
And who is that? Is that finance? Who's putting this advocate on a wild goose chase, knowing very well that there's nothing to catch?
And Chair, I don't know who wrote this